Guys, the First Amendment no longer applies. We no longer have freedom to organize. Sorry, it's actually kind of not an exaggeration. It's not good. It's not good. So yeah, basically the Fifth Circuit, the district court, which is packed full of lunatic Trump supporters, has been going after a specific civil rights activist because he was heading a protest where a member of that protest threw a rock at a cop and injured the cop. So basically, the cop sued that civil rights activist leader. And the question was, real tough question. Think about it. Should it be legal to sue the organizer for a protest for the actions of people who attend that protest? Now, I want you to think about it, okay? I want you to think really, really, really hard, okay? No. Think of all the ways that could go wrong. First of all, in any large protest, if anything gets even remotely rowdy, like that's all on you, you're now legally liable. You could claim anything for anything under any circumstances. What about counter protesters? What about false flags? Literally, you could show up with a bandana over your face, hit somebody with a brick, and then run off. Congratulations. That person who's been bricked could now sue you, the organizer. You might have been organizing a completely above board, legitimate, like licensed, permit afforded, like all of that. Congratulations. You're now on the hook for attempted murder. This battle's been going on for years between the Fifth Circuit and DeRay McKesson, prominent civil rights activist and organizer within the Black Lives Matter movement. Now, the question was, when this goes to the Supreme Court, what are they going to do? Because to be clear, okay, the idea that you can hold the organizer of a protest liable for any actions committed within that protest is a flagrant violation of the First Amendment. There's no ifs, ands, or buts about it. It is obviously, objectively, not allowed. Like, the First Amendment protects you from that. That would be an unconstitutional law. Okay? I think this article actually goes a little bit more into it and talks about a precedent on this particular case. Here we go. It should be obvious why protest leaders must not be held legally responsible for the actions of random protest attendees. No one will ever organize a political protest if they know they could face financially devastating liability if a reckless or violent individual happens to show up. Obviously. Yeah, of course. Indeed, as Judge Don Willett, a Fifth Circuit judge who dissented from Elrod's opinion, Elrod's the Hitler here, pointed out, Elrod's approach could potentially force protest organizers to pay for, quote, the unlawful acts of counter-protesters and agitators who show up for the very purpose of undermining the protest organizers' political goals. Under Elrod's opinion, McKesson could be held liable if the unknown rock thrower turns out to be a member of the Ku Klux Klan who showed up for the very purpose of undermining the Black Lives Matter movement by associating them with violence. And to be clear, even if it was found out that that person was a false flag operative who was with the KKK, the organizer would still be liable. Like, we are talking about levels of liability that are this functionally removes the right to protest. You can't do it anymore. In their petition to the Supreme Court, McKesson's attorneys made an audacious ask, claiming that Elrod's, quote, decision is so flatly contrary to this court's controlling precedent to be appropriate for summary reversal. So that's an insane thing to say as a defense attorney. What you're basically saying is the district court has made an argument so obviously unconstitutional that you should reverse it without explanation. Through summary reversal, without ruling on it or providing an argument, you will essentially be saying, like, this was so bad that it doesn't even deserve consideration. For a judge to have their ruling reversed by summary reversal, which is incredibly rare, this is like the death knell of your career. Like, this is like God reaching down from the heavens and saying, no. There are some arguments down here that continue to explain Supreme Court precedent on the matter. To understand just how ridiculous Elrod's decision is and how egregiously she defies the Supreme Court's case law, it's helpful to start with the facts of the Claiborne case. Like McKesson, Claiborne involved a civil rights activist who organized a protest that allegedly included some violent individuals. In 1966, Charles Evers was the field secretary of the Mississippi chapter of the NAACP. In that role, he was the principal organizer of a boycott against white merchants in Claiborne County. Wow, reverse racism? Wow, wow. The Mississippi Supreme Court claimed that some of the individuals who joined the boycott also, quote, engaged in acts of physical force and violence against the persons and property of certain customers and prospective customers of these white businesses. Evers, meanwhile, allegedly did far more to encourage violence than DeRay McKesson is accused of in this case. He allegedly gave a speech to potential customers of these stores where he said that, quote, if we catch any of you going into any of them racist stores, we're going to break your neck. Sorry, damn neck. The Supreme Court nevertheless held that this, quote, emotionally charged rhetoric did not transcend the bounds of protected speech. Claiborne also warned that courts must show extreme care before imposing liability on a political figure of any kind. So, going back, even to the civil rights era, I mean, there's more precedent listed, but it is very, very clear that the ruling of the 5th District Court is insane, a violation of our First Amendment rights, and the Supreme Court should overturn it. Like, it's insanely, it's not even that it's conservative, which it is. It is, of course, conservative. I think it's very fitting, by the way, that the case being referred to here happened during the Black Lives Matter protests, and then as a comparison, we're talking about the Civil Rights Act, you know? Like, it just seems fitting to me. You know, same shit, different day. So what do you think the Supreme Court did? They refused to hear the case, thereby upholding it in Louisiana, Mississippi, and Texas. They didn't even take it, thereby allowing the 5th District Court's ruling to hold. How? By not holding it. The Supreme Court announced on Monday that it will not hear McKesson versus Doe. The decision not to hear McKesson leaves in place a lower court decision that effectively eliminated the right to organize a mass protest in the states of Louisiana, Mississippi, and Texas. Under that lower court decision, a protest organizer faces potentially ruinous financial consequences if a single attendee at a mass protest commits an illegal act. It is possible that this outcome will be temporary. The court did not embrace the Fifth Circuit's decision, the Court of Appeals of the Fifth Circuit's decision attacking the First Amendment right to protest, but it didn't reverse it either. That means that for now, the Fifth Circuit's decision is the law in much of the American South. And that's that. Would this extend to any organized event, such as a parade or concert? I'm not sure if there is a legal distinction here between mass protest and other forms of mass organization. My guess is that a protest would have to be defined legally in any court proceedings that took place. That is to say, when being sued for the behaviors of people attending the event that you're holding, they would argue whether or not it was a mass protest. Imagine this makes Trump liable for January 6th. I don't know if he would be considered an organizer or if he would be considered the chief speaker. I don't think he would be held liable as the organizer. But of course, that's in D.C. Laws can't be retroactive, though. No, they can't. Or at least they shouldn't be. He was telling people to be there for Jan 6th. That's not being an organizer. Everyone agrees this rock was not thrown by McKesson. The Supreme Court held in NAACP versus Claiborne Hardware that protest leaders cannot be held liable for such and such. Indeed, as Justice Sonia Sotomayor points out in a brief opinion accompanying the court's decision to not hear McKesson, the court recently reaffirmed the strong First Amendment protections enjoyed by people like McKesson in Counterman versus Colorado. That decision held the First Amendment, quote, precludes punishment for inciting violent action unless the speaker's words were intended, not just likely, to produce imminent disorder. I like this section. The Fifth Circuit's McKesson decision is obviously wrong. It is. It really is. It really, really is. Yeah. So what are we talking about then, right? So right now, in 3 states of the Union, the right to protest does not exist. I mean that. I am stating that freely and clearly. I don't think that's hyperbole. I legitimately think that a section of the First Amendment has been carved out. The liability of an organizer means that no one will be willing to organize. That is just, I don't think that's hyperbolic. I think the reason why the Supreme Court wants to hold off here, there are 2 possible explanations that I believe. There are others that I don't believe, but here are the 2 that I believe. 1, they're waiting for Trump to win. They're waiting for the full happening, the reversal of democracy, Project 2025, the end of the Union, so that they can just do whatever they want. It's a possibility. The second possibility, and the one that I personally think is more likely, is that they are trying to make people sweat a bit. See, the Fifth Circuit's ruling is so egregious that a summary reversal probably actually would be warranted. It's revolting how bad it is. They're not doing that, obviously. I think they're trying to make people sweat a little bit, you know? I think that they're trying to show like how close their finger is to the button, if that makes any sense. But that they might go ahead and address it in the future, which they have the potential to, you know. Challenges to this ruling will be brought, right? Just because the Supreme Court is not choosing to reverse this ruling, that doesn't mean that more cases can't be brought against it, more challenges to it. Is it possible they didn't vote on it because Thomas is secretly dead? Okay, if it turns out they didn't vote for it because Justice Thomas is secretly dead, that would be pretty cool. Now, I don't think that's likely, but it would be cool. Unlikely, but cool. Everyone pray. I don't think he's actually dead, of course, but it would be funny. It's a toss-up between him and Alito for a worst justice of all time. It's close. I feel like, yeah, I don't really know. Yeah, isn't it crazy how Scalia has been like not exonerated in retrospect, but like he's so much less bad than so. Like Scalia was like the last hyper evil conservative Supreme Court justice who believed in anything, you know? Like, yeah, he's been completely overshadowed. Like, Scalia did have pretty strong principled beliefs when it came to some stuff regarding, like, protection from the state or police behaviors, like that kind of, like, you know, he believed something. Amy Coney Barrett and Kavanaugh have been relatively moderate compared to, like, you know, Clarence Thomas, right? Like that, I genuinely think that if Donald Trump was more competent, he would have found bigger lunatics, you know. But he didn't, you know. Yeah, Trumps aren't even the most evil. I don't know. I don't trust. No, I'm not saying they're good or anything. I'm just saying like compared to Alito or Thomas, Scalia would have lost it when the court let Texas openly defy the president. Oh my God, I'd like to believe that if Scalia was around for that, he would have been like screaming into the microphone. Yeah, Alito used to be more normal. Am I wrong in thinking this? No. Yeah, for sure. It's just now that like the GOP is openly fascist and openly anti-democratic, they don't have to pretend. You know, they can just be straightforwardly, evil. Well, we'll see. We'll see how it goes.